Welcome to the second module of this course. In this module, we shall go through the core or the key features of the legislation. We shall go through the greater details and the finer aspects as to what this legislation is applicable to, because we need to understand certain words and terms used on the applicability of the legislation. So the provisions of this Act is applicable to processing of the digital personal data within the territory of India. There are three aspects to this. One is processing of the data, processing of the digital personal data, and processing of that data which is within the territory of India. And the data, as we discussed, should be collected from the data principal online, or if such data is collected offline, that data should be digitized. The limitation of this legislation is in relation to how that personal data will get processed. We will understand what is personal data subsequently, and which lies within the territory of India and universally not applicable to across all personal data, but only in relation to personal data which exists online. The Act will also be applicable to personal data outside India, provided that it is in connection with profiling of or in relation to activity of offering any goods or services to the data principal in India. So the data principal should be in India, and the data belonging to such data principal can be processed outside India, provided that it is in connection with profiling that individual or in relation to any of the goods and services that a variety of companies are offering it. Primarily, the legislation applies to the personal data within the territory of India, but with some exceptions, certain data can be processed outside India also. Now, what is processing? The legislation gives a very exhaustive definition to the processing. Processing, in common parlance, we understand that something exhaustive activity needs to happen, but a simple act like just a mere collection of the data or storage of the data can also be treated as processing. The definition of processing covers a variety of activity, including collection, recording, structuring, storage, alteration, retrieval, use, indexing, sharing, disclosure, erasure, or destruction of data. So it looks like any and every activity that you do in relation to the data will be covered under processing. Therefore, the companies and corporates have to be careful on a variety of data that they are collecting from the customers, from their vendors, from their employees, or any third person, the data that is getting collected. Even the mere act of collection of the data and storage of the data can result in attracting the provisions of this legislation. In the context of the example that I gave in relation to the bank account opening, the bank will be responsible under this legislation just for the mere act of collecting and storage of the data, even if they don't do it for any significant activity. The mere act of collection and storage can also attract the provisions of this legislation. The legislation also carries certain exceptions, that is, what is it not applicable to? Any personal data which is processed in a non-automated manner, that is without the use of computers and other systems. If it is processed in a non-automated manner, then that is not a part of this legislation. Therefore, many of the restrictions and the prescribed processes under this legislation are not applicable to processing such personal data. Any personal data which is offline, even to that the legislation is not applicable. We repeatedly discussed that the data has to be online, and only to such personal data the prescriptions under this legislation are applicable. Any personal data that is processed by an individual for any personal or domestic purposes, even that is completely outside the scope of this legislation and not hit by the provisions of this legislation. And any personal data of any person which exists for at least 100 years, even that is not applicable under the provisions of this legislation. In simple terms, it means that any personal data of any person which exists for more than 100 years can be freely used without complying to the requirements under this legislation. So the exceptions are non-automated data, offline data, data processed for personal needs, and any personal data that is in existence at least for 100 years. The stakeholders are one of the key features of this legislation, and the entire legislation revolves around the key stakeholders. The first key stakeholder is the data principal, who is at the center and the core of this legislation. He is an individual whose data will be managed by other people. So any person to whom the data belongs to, that person will be the data principal, and in case where the individual is a child, then the parents or the lawful guardian of the child come into picture and they take the role of the data principal. The second key stakeholder is the data fiduciary. He is a person who either himself or in conjunction with other people determines the purpose why the data is being collected and also the means as to how the data shall be processed. So any person who is processing the data, in simple terms, shall be the data fiduciary. In the example we talked about on the opening of the bank account, the bank which collects and stores and manages the data, the bank will be the data fiduciary in this context. Now, the data collector or the data fiduciary himself may not have the entire capacity and capability to manage data, and he may engage third party to process the data. So any person who processes the personal data of the individual on behalf of the data fiduciary, he shall be called the data processor, and he shall also be one of the key stakeholder in this legislation. However, the legislation, even for the acts of the data processor, holds the data fiduciary responsible for it. So therefore, the primary key stakeholders are data principal and the data fiduciary. The legislation does not limit as to who can be a data fiduciary. Therefore, it defines as any person who determines the purpose of collection and means of processing of data. So therefore, person under this legislation includes any individual, company, firm, association or person. So anybody who is collecting and managing the data will become the data fiduciary, and the entire legislation revolves around the interactions of the data principal, data fiduciary and the data processors. In the previous slides, we discussed about what this legislation is applicable to, what is it not applicable to, and also who are the key stakeholders. In this slide, we shall understand the other core features of the legislation. The other core features are the data can be processed only for lawful purposes. Goes without saying that no unlawful activities can be carried on the personal data of individuals. The data shall be processed only in accordance with the provisions of this legislation, except for the exceptions carved under this legislation, where the provisions are not applicable, like in offline data and non-automated data. The rest of the data processing shall be complied with as per the provisions of the legislation, and it cannot be handled in a different way. The data can be processed only with explicit consent of the data principal or the deemed consent of the data principal in certain cases. One of the significant achievements of this legislation would be where the individual has been given the right of the consent, and only upon his consent will the data get processed. Without that, no data can be processed by the data fiduciary. This will bring in a lot of transparency was required in terms of how the individual's data is being used. Where the individual is a child, then the consent of the parent is a must for processing of the personal data. The other key feature of this legislation in terms of data processing is that no retention of data is possible beyond the purpose for which it is collected. In the example that we discussed of opening a bank account, if at a later date I decide that I want to close the bank account and inform the bank accordingly, then after the closure process is completed, the bank has to do away with the data. They cannot retain my personal data endlessly even after the closure of my bank account. This is also a significant change to the current situation, where today your personal data can be endlessly retained by a variety of people. Once this legislation is in place, no retention of data is possible against the wishes of the data principal. The legislation also contains a lot of prescriptions in terms of what are the obligations and duties of the data principal and data fiduciary. Primarily, the biggest burden of all the rights, obligation and duties is on the data fiduciary, because he has to undertake a variety of things in order to comply with the provision of legislation. In the upcoming slides, we shall go through this in greater detail. The Data Protection Board also plays a significant role in administering the data processing as per the law. It will administer and monitor the compliance with the legislation, and also has the powers to levy significant fines and penalties, and therefore it is critical for any person, any company or any corporate who is managing the data to ensure the compliance with this legislation, because the fines and penalties can be too steep. The important aspect that we discussed in the legislation is about the consent and the deemed consent. We shall again go through this in greater detail. For this module, we can understand that there are two types of consent. One is which is explicitly given by the individual for processing the data. This is freely given, very specific. It is an informed decision and it is unambiguous. So what has been given as a consent has a clarity that can be understood by data fiduciary for processing the data. The other portion is a deemed consent, where the explicit consent of the individual is not required. I don't need to specifically say, yes, I agree to process this data. These are situations of medical emergencies, safety measures, or compliance under the law, or an exception has been carved out for an employment purpose where the employee data is being processed by the employer. In such context, the sharing of data itself will become a consent for its processing, and further explicit consent will not be required. We shall discuss the consent aspect in the upcoming slides. We have come to the end of the second module on key features. In the third module, we shall go through the various rights and obligations of the data principal.